Are you prepared to bring felony charges if Mr. Dan didn't plead guilty to these two misdemeanors today?
I think we filed the charges that were negotiated. I think I would not comment on what charges may have been filed had this agreement been reached. I think the investigation that you now have a copy of will speak for itself as to what kind of conduct was ultimately in the lengthy investigation discovered. But I think I would echo what Mr. Freel just said, and note that sometimes offenses are generally referred to as ethics offenses, and some people think that a violation of ethics laws is not a criminal offense. It is a crime in the state of Ohio, the offenses we're talking about. And the crimes in the state of Ohio of any kind or nature are contained in Title 29, the Ohio Revised Code, and at least the providing supplemental compensation is in the criminal code of the state of Ohio. It's not in 102, Chapter 102, which is where the ethics laws are. So one of these charges was an ethics violation. One of them is a charge that was in the criminal code. So I think there were both ethics violations, even though reinforcing that ethics violations are indeed crimes themselves, but the crime of unlawful compensation is in the criminal code of the state of Ohio, and that's a crime for which the plea had been entered as well.
I think you should know, too, that Judge Barrows executed the most severe sentence on a statute that says you cannot knowingly falsify a public document filed before the Ethics Commission that's about transparency and disclosure, and that the Attorney General was admitting he falsified transparency to the public as the former Attorney General, and from the judge's own sentence it's clear that he found that to be really very serious violation of law.
And a quick question.
And I think, Paul, if I would just follow up on that one regard, I think it's important to know many people, and some of the people who posted stories yesterday, being an informed public official, I sometimes read those and sometimes read the comments of citizens below those stories. Some people kind of thought, well, gee, is he going to get a $1,000 fine and a slap on the wrist, when I heard about the 500 hours of community service and added that up in my mind and divided that, that's 12 and a half weeks of community service. There's a 2-year period to serve it, but that's more than 3 months on a full-time basis of community service that's being required. And I think those of us who handle these cases and have handled them over the years, I think that the sentence that Judge Barrows gave is the most serious that I remember. And I, during the time I was city attorney, handled these cases at the misdemeanor level and handled cases involving council members, commissioners, former members of both houses of the legislature. I've been around long enough that's a broad expanse, but I think this is probably the most serious sentence that I can recollect being imposed, and perhaps for the kind of reasons David identified.
And socially, I'll get out of your hair. Socially, what do you think that means to this community, to the state, that you went through this process, you held the former Attorney General to a great deal of scrutiny? Does it restore or maintain people's faith in government?
Well, I think it shows that the matters came to the attention. They were properly investigated. Perhaps it took longer than I would have liked to seen it have taken, but that was not my choice. I would have hoped to resolve this on this kind of a basis a year and a half ago, and frankly attempted to resolve it on the kind of basis it resolved today. But I didn't have...
From the Ethics Commission's vantage point, we're frustrated it wasn't resolved earlier, and some of that was outside the control of the prosecutor and the Ethics Commission.
Well, we need to have witnesses to prove cases, and while we can prove something and have statements, that person may give a statement to the Inspector General, but there's still not a state's witness raising the right hand that I can force into a courtroom to testify what they may publicly say, because they still retain a Fifth Amendment right not to be compelled to give information. And using both Mr. Gutierrez and Mr. Jennings as examples until they themselves pled guilty and resolved their cases with plea agreements that this was their charge, this was their penalty, and there was no other Fifth Amendment complications forcing them to testify what they knew. That information was useless to us. And so until very recently, we did not have what you had the front pages of your paper a year and a half, 2 years ago or more. We did not have available to us, and we had to go through quite a few steps to get there, but we resolved to get there, and we did, and I think that's just the process, and I'm not complaining about the process, but that is the process, and I think in response to Paul's inquiry, we followed that process, and I think, I don't want to necessarily say the system worked, but I think the system did work through the steps that are necessary to reach this point, and I think, unlike, I might add, as you all know, covered Governor Taft's case. He pled guilty to 4 ethics disclosure violations. He did it in a matter of a month or more. He did it quickly. He pled guilty. We didn't have to charge people in his office, go through a process of forcing people to testify, entering into plea agreements. Came in, said, I did it, I'm sorry, and it was done quickly and appropriately. And I was hopeful this would be accomplished in the same manner. It wasn't, but that's our system, and again, I'm not complaining.
There are 2 fundamental principles here for clarity for you folks that you know about, that you've written about. One is the clear notion of disclosure and transparency of sources that can improperly influence public officials through disclosure. But the other one is that only the public pays people in senior roles in public service for their services. When you have other outside sources of income and assets coming in to supplement a public servant's salary, then there are divided loyalties to the public and to others, in this case potentially to the senior office holder. And that's when the public's really troubled. You may not know, but the statute for which the former Attorney General was convicted was intentionally strengthened in the mid-'80s to prohibit campaign funds being paid as supplemental sources of income for public officials as a result of problems in the former Governor Celeste administration with campaign funds being paid to the former Lieutenant Governor, Merle Shoemaker. So the statute here was intentionally strengthened to prohibit those kinds of sources of compensation for public officials on the basis that they would have split loyalties in terms of who they were working for.
Do you know how much?
And let me just say one thing, Jim. The report that you just got, and you probably haven't had a chance to look at it, contains 38 pages. Among the things you probably haven't publicly reported that was able to be detected in this investigation, pages 33 to the end indicate that in connection with attendance at a Democratic Attorney General's Association meeting in Phoenix, Arizona in January of '07, that Mr. Dan was picked up by a private aircraft at Lake Workfront Airport in Cleveland, that it flew to Austin, Texas, that at that time, and the manifest of that flight would show the presence of certain people, but the $20,000 was what the cost of this trip from Austin to D.C. to pick up a man named Franklin Hall, who was a political fundraiser for Mr. Dan. Picked up Mr. Dan then in Cleveland. Mr. Gutierrez went on that trip. His family went on that trip. They went to Austin, Texas, then they went to Phoenix, Arizona, and then they were ferried back to Burke Lakefront at no cost to Mr. Dan. The cost to the man that provided it, a former Speaker of the House in the state of Texas and a lobbyist in the state of Texas, lobbyists for some interests that were concurrently lobbying in the state of Ohio. All those things, there was a $20,000 out-of-pocket cost for that transaction. That wasn't reported. It's a kind of transparency, and that never became, I don't think, known publicly to any of you all. Wasn't reported, but that kind of thing was detected, observed, and is noted in the report that you'll see, and is one of the charges in count 2, the private aircraft that took him upon that trip. We don't believe that there was anything improper happened on the trip, but I think you can look at the circumstances themselves and with some due diligence may make some further inquiries yourself as to who was on that trip and what was the purpose of the trip and who were the people involved and so forth.